Uh, the name you have on the case and who I am, it's two different people.
You want to smile about it and laugh about it? Take him back.
Laugh.
We'll call him out later. Take him back. You keep laughing. You laugh one more time, that's 30 days. Go contempt. Look it up. I'm not threatening you. Say one more word and that's contempt. 30 days. 30 days.
This courtroom hearing features one of the most intense exchanges we've seen in a while. The individual at the center of it, a self-identified sovereign citizen, pushes the boundaries of courtroom. Decorum with constant interruptions and a highly combative attitude. His behavior makes it seem as if he's inviting trouble. And the judge doesn't hesitate to push back with authority and clarity. Sovereign citizen tactics often clash hard with the reality of the legal system. And this case is a perfect example of how that plays out in real time. The courtroom doesn't entertain attempts to dismiss its authority. And this hearing makes that crystal clear. What are your thoughts on how the judge handled it? Was the response firm enough? Let us know in the comments, and be sure to like and subscribe for more real courtroom moments. Let's dive into the full exchange.
Some confusion.
What's the confusion?
I've stated multiple times on the record that I wish to represent myself.
Well, I thought we got rid of that issue the last.
Yeah, I thought so too. I spoke to this gentleman right here and expressed my wish to represent myself as well.
All right. Well, if he doesn't want you, I mean, we'll figure that out in a moment. So, Mr. Styron, we're going to go through this again. What do we want to do in this case? You understand what you charged with, sir?
I understand what the charges are against me, yeah.
Okay, look, you're going to have to give me straightforward answers to my questions because I've got to make sure that you understand certain things. I got to do certain things here.
From my understanding,
you understand, first of all, that if you do be direct, you want to smile about it and laugh about it, take him back. We'll call him out later. Take him back. You keep laughing. You laugh one more time, that's 30 days. Go contempt. Look it up.
Up surprisingly fast. Judge Simpson once again showed exactly why he's known for taking a no-nonsense approach with sovereign citizens. His steady and direct handling of these cases is something a lot of people appreciate. He doesn't let the courtroom turn into a spectacle. Still, you have to wonder what the strategy is on the defendant's side. From the outside, it really does seem like he's not taking any of this seriously, smiling and laughing as if the entire proceeding is a joke. It's hard to understand what the end goal is, especially when no sovereign citizen arguments have ever succeeded in court. The whole movement continues to puzzle a lot of observers. If anyone has insight into why these individuals persist with this approach despite repeated legal failures, feel free to share it in the comments. Let's take a look at what happens next in his upcoming court appearance.
my name is Thomas Styron. Living man.
Mr. Styron, you are before the court. You have elected to represent yourself. I do have to advise you that you have 3 counts against you. The first count is that of fleeing and eluding 3rd degree under the Motor Vehicle Code. Do you understand the nature of that charge, sir?
This is under the assumption that you're compelling me to identify as Thomas York Styron, the legal entity on this case.
I believe that you are. Do you understand the nature of the charge, sir?
I don't understand how the name you have on the case and who I am, it's two different people.
I have a complaint, Thomas Styron II. Do you understand that that individual is charged with fleeing and eluding 3rd degree?
So,
do you understand the nature of that charge? You just need to answer my question.
For the record,
take him back, and when he decides he wants to cooperate, we'll bring him back. Maybe. I'm not threatening you. Say one more word, and that's 30 days. 30 days.
Clear this individual wasn't interested in cooperating, and the 30-day contempt sentence was probably inevitable. Judge Simpson gave him multiple opportunities to respond appropriately, but the defendant continued pushing the boundaries. It's as if common sense just wasn't part of his approach. At this point, it's hard to understand what the goal was. If there's a strategy, it certainly isn't working in his favor. Let us know in the comments, what do you think was going through his head during all of this? Now let's take a look at what happens as he returns for a third time. Things are only getting more unpredictable.
Case, people of the state of Michigan versus Thomas Styron II. Styron, you are before the court on a felony complaint that does allege count 1. But I'm going to presume, since you do not want to answer the court's questions, that you understand English and understand what I'm saying. You are before the court on 3 charges. Count 1 is the charge of fleeing and eluding 3rd degree. Under the Michigan Motor Vehicle Code, that is a felony punishable by up to 5 years incarceration, a $1,000 fine plus court cost, and would require the Secretary of State to suspend your license for up to 1 year upon conviction. Count 2 is assaulting, resisting, and obstructing a police officer. That is a felony or high court misdemeanor punishable by up to 2 years incarceration and or a $2,000 fine plus court cost. Count 3 is a misdemeanor offense of operating with a license suspended, denied, and or revoked. That is a misdemeanor as indicated, punishable by up to 93 days, $500 fine plus court cost. Your vehicle could be subject to immobilization. Since you refused previously to answer my acknowledgement as to whether you understand that, I will assume that you understand what you're charged with. You are also entitled to be represented by counsel at this and all subsequent proceedings. If you could not afford to hire an attorney would be provided at public expense to represent you in this matter. You are entitled, as indicated, to be represented at this proceeding, all subsequent proceedings, including your preliminary examination, and if the matter were to proceed by trial, you would be entitled to counsel. It is, as we have gone through the previous proceedings, the court's understanding that you do not wish to be represented by counsel, and that this matter will then proceed forth with you representing yourself. I have to advise you that in representing yourself, the court will make the presumption that you understand the Michigan court rules, those regarding both procedure and those regarding evidence. The court will not be providing any legal assistance to you during the course of those proceedings and will hold you to the same standards that I would hold an attorney representing or practicing before this court. So, with all of that, and with the court's understanding that you do not want to be represented by counsel, I will set this matter for its next proceeding.
You understand I'm the beneficiary, not the trustee, right?
That will be the preliminary examination. I will set the preliminary examination. Has discovery been provided to the defendant?
Your Honor, he was previously represented by the public defender. I don't know if he turned over the paperwork to him.
Does anybody from the public defender's office know whether or not the defendant has been provided discovery? Mr. Odetella. Thank you, sir.
Thank you. Your Honor, we have the discovery. I have not been able to share that discovery with Mr. Styron. I tried to speak with him and go over it, but I'd be happy to turn that over to him at first available.
All right. If you would either turn that over to the court officer so that they can provide that to Mr. Styron so that he has some discovery. And if you could do that today, I would appreciate it.
Yes, Your Honor.
I'm setting the preliminary examination. Thank you, sir.
Yes.
The people would have their witnesses available June 11th. Set this matter for preliminary examination in person, June 11th, 2024, 9 a.m. That is before me. Defendant, as he was leaving the courtroom the last time, the court did find the defendant in contempt, sentenced him to 30 days. The defendant will serve that sentence. The court will sign the judgment of sentence regarding the contempt.
I don't understand how that's possible. Like I said, I'm
So
the
first of
man.
all,
I'm
watch
gonna
your
make sure you're
language.
treating me as if I'm the trustee, or I don't want to partake in any trust fraud or anything like that. Is this a SQV trust matter involved in this? Is my social security number attached to this at all? Go figure.
Styron, or whoever you wish to be addressed as, I'd suggest that you watch yourself because there's going to be more time coming. You keep it up.
You're
You will
presuming
learn, you will
jurisdiction
learn
over
how
me.
to conduct yourself appropriately in these proceedings in this courtroom and before me. You will not in any manner whatsoever
You're trying to
disrespect
compel me
me
to be somebody I'm not.
or this institution.
You have no evidence
It will not
to prove that
happen.
I'm who you say I
You
am.
will not talk to me in that fashion.
In what fashion? I'm not the one being unethical.
Very good. You'll serve the 30 days. We'll see. We'll see him on the 6th. Bond continues.
Judge handed down a 30-day contempt sentence after repeated disruptions. And many would agree it was a necessary step to maintain order, despite multiple chances to adjust his behavior. The defendant continued with arguments that had no legal basis. This kind of exchange highlights the challenges courts face when dealing with individuals who reject standard legal procedures. Judges are expected to stay firm and focused, and in this case, the response was measured and appropriate. Let us know in the comments, was 30 days the right call, or should it have been more? Thanks for watching, and if you're interested in more courtroom coverage, be sure to subscribe for future updates.